Good afternoon. Welcome back, everyone. Now we are going to continue our discussions for work stream 2, protocol 1. I'm giving the floor back to Lisa. We are going to continue and resume the floor for multi-stakeholders who was there in the loop before we go to the lunch break. Lisa, please go ahead.
Thank you, Chair. We had actually a member country, but we just is disappeared. So we'll start off with and invite the stakeholders to make their comments. And I first have stakeholder 10, Bombay Chartered Accountants Society. Sorry, we just Senegal. Could you wait, Senegal, until after the first stakeholder, if you don't mind, because I've called on them. So please go ahead, Bombay Chartered Accountants Society.
Thank you, Chair, for the opportunity. I have a few comments. First one is on, there's a lot of discussion on auto-operating or the word which is used here is self-executing. Of course, this term has a meaning which is well explained. But the way I would want to, understand, or maybe the most relevant in this context, could be something like like a BEPS MLI, wherein once a country signs or offers a particular tax treaty, in the future, whenever the counterparty agrees to it, the treaty becomes operational. So in the OECD legal note, they call it as an open offer, and maybe that feature of the arrangement may be kind of treated as a part of a self-operating protocol. There's a question on fast-track process. Obviously, it has to be fast-track process. We already spent a lot of time. OECD started BEPS 1.7 in 2012. There's no outcome till 2025. And if we still make it, bilateral, one-on-one, probably it may take 10, 15 more years. All of us may have retired by that time, except for the young people sitting behind. The question of rates, that can be included or addressed in a particular manner. Can we think of a situation or a structure of protocol wherein we adopt minimum standards? Minimum standard could be, let's say, a rate of 5% or 10%. So everyone who signs the protocol, would agree to it. Or minimum standard could be net basis as well, whichever way the countries may want to do. So either of these two. And then with a commitment to further improve on it, if the counterparty agrees. So if we look at the BEPS MLI, some countries, especially India, has said that we want PPT. But if we get a relevant party who is interested in detailed LOB, in the future we want detailed LOB. So if we adopt this method of adoption of rates in the protocols, maybe everyone who signs has some skin in the game, and at the same time, the source country has the ability to further negotiate it and improve the rates if they want. Thank you.
Thank you very much, Raval. I have Senegal. Please go ahead, s'il vous plaît.
Merci, Madame la Présidente. J'ai pris la parole parce qu'au moment de clôturer votre dernière intervention, vous avez souligné que l'objectif du protocole était de corriger les déséquilibres notés dans l'allocation des droits d'imposition nés de traités existants et qui ont été soulevés par les pays en voie de développement. Si nous nous inscrivons dans cette perspective et que nous considérions le protocole, comme ça l'est le cas aujourd'hui, comme étant optionnel, et que le pays fournisseur de services déciderait de ne pas prendre part au protocole, et parce qu'il est dans une situation confortable au regard des conventions fiscales qu'il a eu à signer. Est-ce que l'objectif que nous visons serait le cas échéant atteint? À mon avis, non. Et si tel est le cas, Serait-il nécessaire de même continuer à discuter sur un protocole de ce genre? Je pense que la question doit être ouverte et mériterait d'être débattue de façon plus approfondie. Si nous continuons suivant cette logique d'optionnalité et que la même situation se présente, tous les pays fournisseurs de services décident de ne pas être membres de ce protocole, de ne pas le signer. Est-ce qu'il y aurait des alternatives qui pourraient nous permettre de corriger ce déséquilibre qui a été constaté? Et est-ce qu'à l'état actuel, des réflexions sont en train d'être menées par rapport à une telle alternative? Ce sont quelques questions que j'aimerais porter à votre attention suite à votre intervention pour savoir réellement ce qui pourrait en être et les différentes alternatives possibles. Je vous remercie.
Thank you, Senegal. I think I might take the opportunity because over lunch we had some conversation, and I think we have stressed one of the issues that have been raised in the issues note and during the discussions is that many countries have, but not everyone, has the right in domestic law to charge withholding taxes on non-residents that provide services in their country. But not everyone has that. And also, the fact is that there are countries who don't have double tax relations. And we've sort of said, we've focused a little bit the discussion on the problems that many developing countries raised in the work stream meetings, that the main problem as they saw it was the tax treaties they had entered into and the difficulties of renegotiating them and the difficulties of denouncing them. And we mustn't forget that this is not only about this. I just wanted to stress that taking the opportunity where Senegal has just raised some of the issues that are related to that. I think we still have to remember that the scoping is more than what we are perhaps thinking, or perhaps what I have said, that we should be aware that the scope is big, and we must look into these different possibilities that Senegal has just raised. So thank you for that comment, Senegal. So I will carry on with the stakeholder list, and now I have NGO 4, which is Oxfam. Please go ahead.
Thank you, Madam Chair. The discussions held yesterday confirmed the view that both developed and developing countries are severely restricted when designing and implementing taxes on the income from cross-border services, particularly digital services. A main reason for such limitations is exactly the widespread use of double taxation agreements between countries, as highlighted by the issues note. While the traditional narrative from wealthy countries and international organizations has consistently promoted double taxation agreements as the key to unlock foreign direct investment, provide legal certainty to investors, generate economic activity and additional revenue for developing countries, the concrete impact of such agreements is much more controversial. Analysis from academia, civil society organizations, and developing countries have repeatedly concluded that double taxation agreements are instrumental to profit shifting by creating loopholes and tax avoidance opportunities for multinational corporations, severely limiting or fully preventing some forms of taxation and reducing effective tax rates. The main stated purposes of these agreements is avoiding double taxation. However, methods to avoid double taxation are not limited to such agreements. There are other approaches that are commonly utilized. As recognized by delegates during yesterday's sessions, many of these agreements were actually entered into by countries in the past decades without a full understanding of their practical effects on the limitation of domestic taxation rights. The fact that some agreements were signed during colonial times and continue to be in effect long after independence also reflects the need to rethink the role of such agreements moving forward. A bias towards residence taxation of services and outdated concepts of permanent establishments were disseminated through these instruments, creating the very issues we are currently trying to fix. Just as many countries, both developed and developing, are questioning the impact of bilateral investment treaties and the limitations that investor-state dispute settlement mechanisms have on progressive policies, this Framework Convention on International Tax Cooperation provides a unique opportunity to reevaluate the role and practical impacts that double taxation agreements have over developing countries. Finally, on the question of having a similar structure to the MLI, civil society organizations do not consider that a positive approach, as it would surely lead to a high degree of complexity. Thank you very much.
Thank you very much. I have Ataf. Please go ahead.
Thank you, Madam Chair, for giving Ataf the floor. We appreciate members' contribution to this discussion, and we want to quickly respond to a few points. Number one point is the point which was first raised by Cameroon and has been repeated by Senegal, and it relates to how the obligation raised on parties could be discharged. Obligation raised on parties via the Framework Convention could be discharged using the protocol, since the protocols are optional. We want to believe, Chair, that the best way to go is to ensure that the obligation raised in the framework is such that parties or members could meet up with using variety of choices and tools, which we include, of course, the protocol, but we not exclude other optionalities like bilateral arrangements and other measures which they may choose to use to discharge such obligation. Then, having said that, Chair, we will also want to talk about the relationship between the protocol and the convention itself. Madam Chair, we believe that in elaborating the Framework Convention, there must be a portion of the Framework Convention, an article, which we demonstrate or at least provide for the relationship, clarity on the relationship that exists between the framework and the protocol. In addition to that, our experience looking at other framework conventions will show that elements like the objective of the framework convention, the principle that underlies the framework convention, and of course the commitment, we have direct relationship with the protocol. And in the protocol itself, there may be need for a clause to also explain what happens where provision of the protocol conflict, or at least is to be interpreted vis-a-vis the provision of the framework. In many instances, such provision will relate to the fact that the provision maybe in the framework convention will prevail. Now, on the issue of self-executing, we want to say that self-executing instruments have meaning in public international law, and as far as we understand, it means that the instrument developed may not need further measures from nations for it to become applicable. And in this sense, we have members who are divided basically into two. For some of our members, this could be true. For other members, they must take measures within their national or domestic framework for the treaties to operate or become effective. Now, the discussions around self-executing are part of implementing measures, and we support the argument that this discussion should be had once the instrument has been fully elaborated. We believe that the work stream should be given the flexibility to look at the context of their work and then elaborate the treaties, in which case there must be rules that will be of general applications, both to those who have bilateral treaties and those that do not have. And for the aspect of those rules which must deal with bilateral treaties, we support the move to have an FTI as a way to bring in those rules to apply to existing treaty network. Having said that, Chair, we are hopeful that we are finally getting to where we need to be in terms of discussing key issues, and we appreciate contribution made in this regard. We thank you, Chair. Yes.
Thank you very much, and we also appreciate very much the input by Ataf. Thank you. We have now NGO2, which is the major group for children and youth. Please go ahead.
Thank you, Chair. My name is Caleb Lee. Today I'm delivering this speech on behalf of Jorge Valderrabano, a member of Agora, and the FFD Children and Youth constituency of the UN Major Group for Children and Youth. He writes the following: I am Mexican, and since many years ago, my country has been profoundly affected by criminality and violence, where nearly half of our economy operates in the informal and illegal sectors, in activities such as weapons, drugs, and human trafficking. In this reality, criminal organizations often act as de facto tax collectors, extortioning the citizens to profit from the many activities that the state is unable to tax. We believe that the success of this convention hinges on its ability to deliver tangible justice, equity, and accountability for vulnerable communities. A critical part of this process is tackling tax evasion and the mechanisms that enable it. We see a clear path to achieving this by ensuring the protocols address the most pressing issues for developing countries, namely the erosion of their tax base through illicit financial flows. This is a problem that goes beyond a simple technical deficit. It is an issue of sovereignty, security, and the variability of a state to fulfill its social contract. Tax evasions and IFFs in this context are not merely economic challenges, but existential threats that undermine the rule of law and public institutions. We propose targeted mechanisms to combat tax evasion and streamline the adoption of new international standards. The Framework Convention should include commitments to combat tax evasion and illicit financial flows, recognizing them as major obstacles to domestic resource mobilization. The protocol on cross-border services should include a clear definition and provisions to prevent IFS, as these problems pose significant obstacles for domestic resource mobilization, a concern previously raised by Algeria and the African Group. Establishing a clear definition and robust provisions in the services protocol is a vital first step, but it is not enough. The true test of this convention's success lies in the ability to quickly and effectively operationalize these new rules across the globe. This is where a fast-track instrument becomes essential. The FTI would serve as a powerful tool for harmonization, directly addressing the slow and cumbersome nature of negotiating new agreements, a concern highlighted by countries like Spain and the Philippines that support a flexible opt-in and opt-out approach. It would function as a multilateral mechanism to accelerate the adoption of key provisions from the Framework Convention and subsequent protocols into existing bilateral tax treaties. This would help avoid unnecessary duplication of efforts and of taxes, an issue raised by countries like Canada and Hungary. By providing a clear and efficient pathway for implementation, the FTI offers a unique opportunity to better operationalize provisions about illicit financial flows within the vast network of existing regional and bilateral treaties, considering that we left aside a specific protocol to fully address this issue. If the committee incorporates these targeted and explicit provisions, we can draft a truly transformative convention. We stand ready to collaborate on building a global tax architecture that delivers on its promise of a just and equitable future for all. We thank you, Chair.
Thank you also to the Major Group for Children and Youth. We look forward to a collaboration with you. I don't have any other requests for the floor. But we do have more questions, so I suggest we don't hesitate. We just carry on with the next slide. So this is also something that we have picked up from Monday. And it's basically the relationship of a protocol on services with information exchange on services. And we wanted to come back on a suggestion that we heard on Monday with respect to exchange of informations with respect to payments for cross-border services. So there are some points there on the slide. You see them. Such reporting could ensure that income does not go untaxed in the state of residence. It could also be the state of where someone is providing a service without that state knowing that that person is there. That could also be part of that information exchange. Facilitate data and collection analysis. How is it currently collected? How hard would it be to start collecting this data? If it's desirable, should it go in Protocol 1 or in a more general provisions on information exchange in the Framework Convention? And if so is the case, then we could listen to what the plenary thinks here, and then include it here, and then we can have a look at where we're included in the whole framework, so to speak, of our Framework Convention and of protocols. So these are things that we've been listening to, we heard, and we wanted to pick up to hear if there is some input by the plenary, its reactions to what we heard. So this is not a planned discussion. This is just, as you know, we are scoping, and therefore it's important to try and pick up what has been said in the plenary meetings so far, and we've tried to listen to what you've said, and if possible, if you could go more into depth into this, that would be of course very useful. But then again, we know that this is not a planned discussion, so you might want to think a little bit. Very welcome to do that, but if you do have any views already, that would be very gratefully received as well. So I'll pause a little bit. I don't think we can have coffee yet, Chair, but we just started. So but we'll take a couple of minutes to let you think about this and see if you can give us some comments. Thank you. So thank you very much. We have France. Please go ahead, France.
Merci, Madame la Présidente. Je vais essayer d'être bref dans mon intervention parce que je vais sûrement poser plus de questions que répondre aux dites questions. Mais bon, alors si on parle des conventions bilatérales, on a déjà des articles, enfin un article spécifique relatif à l'échange d'informations qui, autant que je sache, fonctionne plutôt bien dans la majorité des cas. Donc j'ai un peu du mal à voir pourquoi est-ce que dans nos travaux, on aurait besoin de faire un nouveau... enfin une nouvelle disposition, ou en tout cas une nouvelle structuration de l'échange. Qu'est-ce qu'on échangerait? Ça, je peux à peu près le voir. Mais est-ce qu'on échangerait quelque chose d'une manière différente, avec plus d'encadrement? Est-ce que ce serait de l'échange automatique? Vraiment, ma pratique peut-être est trop récente, mais en tout cas, moi, je vois vraiment pas quelle portée on pourrait donner dans le cadre spécifique de la taxation des services à un article qui serait différent de ce qu'on connaît déjà aujourd'hui et qui fonctionne, sauf erreur de ma part, encore une fois, dans la majorité des cas, avec une vigilance internationale aussi pour vérifier que ça fonctionne. Donc là, je suis un peu perdu, j'avoue.
Thank you, Franz. Yeah, well, I think many of us are lost on it, but we don't need to, we have time, so we don't need to be short. We can discuss this. And I think the point is that we heard it and we wanted to see if it was a concern. So I have heard one concern from a developing country that there is quite a lot of service providers that are nomads today. And the country where they go to, that might be a sunny beach country, 3 months a year or whatever, and that country actually do not know that this is a service provider in their country. Now, I don't know how to solve it. I'm just saying that, you know, this country might have a taxing right that they don't know about. And that has been raised because they don't know that this person is in their country. So, you know, I don't know if that's something that we could solve. I heard that it's a problem, and today, it's a problem today. So that country in the meeting actually asked if we could strengthen the rules on exchange of information to include this type of persons that move around quite a lot. So that's a sort of practical input into discussion. But again, I agree with Franz. I don't, you know, there are rules on exchange of information, and we're just thinking of if there is anything extra here that members want to raise. But if not, we'll just move on to the next slides. We do have another slide, so. Senegal, please go ahead. And the Russian Federation afterwards.
Merci, Madame la Présidente. Je partage une bonne partie des observations formulées par la France, parce que quand nous sommes en matière d'échange de renseignements, je ne connais pas le mécanisme d'abord qui serait utilisé. Serions-nous dans un processus d'échange spontané de renseignements, ou serions-nous dans un processus d'échange à la demande de renseignements? Et si nous serions dans un processus d'échange de renseignements à la demande, l'un des critères serait que le renseignement ne puisse pas exister dans votre pays. Et si je prends l'exemple par rapport à quelqu'un qui a un prestataire qui est établi dans un pays de résidence, qui est considéré comme nomade et qui effectue une prestation dans un pays tiers, et qu'il y ait des paiements. En principe, c'est un paiement international qui est viré dans son compte au pays de résidence. Donc l'information existe déjà. Est-ce qu'en ce moment-là, on pourrait maintenant recourir au processus d'échange de renseignements? À mon avis, non. Parce qu'il faudrait que l'information ne puisse pas d'abord exister chez vous. Mais l'information existe. Peut-être que vous n'êtes pas allé à la bonne source. Ça, c'est un problème. L'autre élément, par rapport à la collection des données et à l'analyse, il faudrait que nous sachions d'abord ce que nous voulons analyser. Pour l'instant, nous n'avons aucune idée dans le contenu, dans la substance. Donc, on va collecter des données pourquoi? Ou bien on va créer une base de données qui pourrait être utilisée ultérieurement. Autant de questions ouvertes sur lesquelles des réponses sont attendues. Donc, mais toutefois, il y a un élément important où l'échange d'informations pourrait être intéressant. C'est au cas exemple, je donne un exemple pratique. Si nous déciderions d'avoir une base d'imposition qui serait articulée, par exemple, autour d'une base nette. On fait autour d'un montant net. En ce moment-là, il serait important que nous puissions savoir les éléments qui ont contribué à la détermination des coûts qui ont concouru à la prestation. Et le cas échéant, une obligation documentaire devrait s'imposer qui, entre guillemets, fonctionnerait comme, par exemple, un fiduciaire pour pouvoir dire que telle prestation a effectivement une marge de temps déterminée sur la base des coûts et qui devront être justifiés par l'entreprise. Dans ce cas, un processus d'échange de renseignements pourrait être intéressant. Mais hormis ce cas, peut-être l'avancement dans les travaux nous permettrait d'en connaître davantage. Ce sont quelques observations que j'aimerais aussi partager avec vous. Je vous remercie.
Thank you very much, Senegal. You have pointed to some issues that could be interesting then for this work stream. So thank you for that. I have the Russian Federation and then Estonia.
Спасибо за предоставленное слово. Я поддержу комментарии Сенегала в той части, что обмен информацией может быть полезен с точки зрения квалификации услуг, которые могут являться предметом нашего протокола. В зависимости от того, какую налоговую квалификацию будет предложена в протоколе и последствия с точки зрения режима налогообложения, то вот процесс вот этой квалификации он может быть облегчен с помощью стандартизированного обмена информацией. Например, таким образом, чтобы мы, налоговая администрация, лучше понимали, например, о каких услугах идет речь в конечном счете. Акционерные это услуги, услуги между взаимозависимыми лицами, либо это какие-то типы цифровых услуг, которые требуют соответствующей квалификации, которая уже заложена в правилах, которые мы планируем спроектировать. И ускорение, автоматизация этого и стандартизация этого обмена с точки зрения налоговой квалификации может иметь очень серьезное практическое значение. И точно так же я хотел бы отметить, что сейчас, когда мы говорим про цифровые услуги, это общее место, у нас есть серьезные игроки, такие как цифровые платформы, через которые проводятся, они сами по себе генерят значительную прибыль от предоставления цифровых услуг по всему миру. Также они являются посредниками для значительного количества продавцов цифровых услуг. И, в принципе, мы можем рассмотреть, в зависимости от того, какой подход мы займем, мы можем рассмотреть их тоже с точки зрения, скажем, поставщиков информации, необходимой для налогового администрирования. Вот кратко все с моей стороны. Спасибо.
Спасибо. Russian Federation. Estonia, please go ahead.
Thank you. I'm also a bit puzzled by this slide and the questions on it. Perhaps because of my background, Estonia is part of very many exchange of information systems, both OECD and the EU. And I quickly checked, and the OECD and European Council's Convention on the Mutual Administrative Assistance in Tax Matters has 151 participants. It's not fully inclusive, but pretty close to it. So I have also a similar question to France, that are we really going to add much value if we come up with a new instrument rather than try to make the existing ones work? But just a couple of comments what we are doing at the moment. We usually don't collect data on the payments to non-residents that we do not tax under the domestic law. As soon as there is taxation, even if it's relieved by the tax treaty, then we collect the information and then we also exchange it. If we're talking about digital nomads, then my first thought was that this could be more of a concern or an issue to solve domestically, because if you have a border control that many countries do have, you should know who is in your country. And of course, it will be with a different authority, unless the customs registers this person, but also customs and tax administrations could be separately, but it should be achievable within one jurisdiction to establish whether and how long a person is in the territory and when this person leaves. And when they leave, they usually end up in another country unless they get lost in the, I don't know, not in the airspace, but perhaps in international waters for a while. So it seems that perhaps there's something that can be done domestically in terms of individuals. And I do hope that if we're talking about information exchange, that then at first we assess whether we can use the existing international framework. Thank you.
So I will come in here with my reflections on the questions that I see in the screen. I think here we're more talking about using the exchange of information as a tool. If you go to the last point, it says if such a provision on information exchange is desirable. It's not talking about set a new exchange of information standards and rules that should exist in this protocol, more than that if this can be one of the tools in protocol one that can use to solve this problem, then this tool where it is, then it's something else. Like where it is now, it can be used or coordinated to coordinate with it in a way or another. But here I think it's more mentioning the exchange of information and as one of the tools, more than saying that it to introduce something new or to have new standards different from what exists currently. This is my understanding for the slide and for the question.
Thank you, Chair. And I have Saudi Arabia. Please go ahead.
Thank you for giving me the floor. I think if we are talking about information, do we need information? Definitely we need information to be able to enforce what we are going to develop. Now, the other question, do we need to exchange some information among ourselves? I think this question will take us to what we have highlighted before, is that unless we are clear on what the issues is and what we are trying to address and what are the models that we are going to find solution for, we will not be able to assess the information needed, because we need to, in order to assess the information needed, we know what we are trying to solve exactly here, and then we look to what is available today with us, and whether we need a new mechanism that to exchange a type of information that is not available today to the member jurisdiction. So that's, I think, we need that before we can jump to what type of information that we need to exchange among ourselves. And I think when it comes to whether should we have something in the protocol or in the convention, I'm not sure, honestly, that we should embed such thing in the convention, but rather if we are going to do it, it will make more sense to me to have it as part of the protocol rather than of the convention. And also, I think also we have some colleagues have highlighted that today there are some instruments and there are some mechanisms to exchange information. Maybe is accessible to all, but not accessible to some. So that's also a question that need to be considered when whatever we are going to develop to address that issue, and also the issues of capacity building when it comes to the information that is being exchanged today between member jurisdiction, how to use that information is also for the purpose of the protocol that we are going to develop. So that's my comment. Thank you.
Thank you very much. That was very helpful. There is a role for exchanging information when you deal with services, and we will. I'm concluding that we will keep our ears open to see what that role will finally be, if it's really something that is missing from the actual framework, which we know there is a huge framework out there on exchange of information. But we will keep our eyes open to see if there's anything that we could add to that, which would be specifically needed for our purposes. I have Côte d'Ivoire, s'il vous plaît.
Merci, Madame la Présidente. Je serai très bref, d'autant plus que vous avez abordé une partie de mes préoccupations. Alors, il faut pas oublier que nous sommes en train de parler de la taxation de services transfrontaliers. On parle de services transfrontaliers donc qui débordent une frontière. Alors, a-t-on besoin d'échanger des informations pour établir, on va dire, une taxation équitable de ces services transfrontaliers? Oui. De façon indubitable, oui, effectivement, pour taxer des services tasser de façon équitable des services transfrontaliers, nous avons besoin d'échanger des informations. Alors, quel type d'informations avons-nous besoin d'échanger? Je crois que les travaux, on va dire, plus approfondis sur les différents protocoles nous diront le type d'informations que nous avons besoin d'échanger. Troisième question, est-ce que les mécanismes actuels d'échange d'informations sont satisfaisants et permettront d'échanger le type d'informations que nous aurons identifiées? Il me semble que aujourd'hui, au regard de la nouveauté de ce type de service, les mécanismes actuels peuvent paraître rigides. Mais en tout état de cause, les travaux futurs nous diront ce qu'il en est de façon exacte. Alors, notre position, on va dire à chaud, sans avoir eu le temps de prendre suffisamment de recul par rapport aux questions qui ont été posées, c'est qu'il faut envisager effectivement d'aborder la question de l'échange du renseignement, d'informations. Faut-il l'introduire dans le protocole ou dans la convention cadre, ou faut-il en faire un protocole particulier, spécifique? Je pense que pour le moment, le niveau de réflexion auquel nous sommes est encore trop basique pour répondre définitivement à ces questions. Merci.
Merci beaucoup, Kotavar. So we have heard some input and we will therefore keep our minds open to what is necessary for the work forward and having the information that is necessary, and we will see where it fits into our whole project of a framework convention and protocols. Do you want to say something, Patricia, Secretariat?
Only if the co-lead is happy to have me do it. But so this, as the co-lead said, this question, the first question, did not come from us. This was a suggestion that was made on Monday. But as we thought about it, we thought it was worth discussing, and I'll give two reasons. One, before I came here, I was working in academia. I was doing some consulting for a non-U.S. company. And I received a payment from of course, with respect to U.S. clients, I got a 1099 that was reported to the IRS. But when I was working for non-resident companies and getting paid, the IRS had no idea that I was earning that money. And so, of course, I reported it, but one could imagine that others might not, because there is no automatic system of exchanging information, as far as I know, of exchanging information with respect to cross-border services. And that can be important if you're dealing with, it doesn't even have, I was going to say neighboring countries, but it doesn't have to be neighboring. There was a whole ocean between me and the company paying me. So that's one point. Yes, maybe the mechanisms exist, but they maybe are not used. And I don't know how the IRS would have ever asked, frankly, known to ask in that case. And the other point is one we've spent a lot of time, or we've heard a lot about economic analysis. And I've talked to a number of people who have tried to do research in this area. And the difficulty that they have had is that the trade data on services does not sort of map to the current categories in tax treaties. Which means if you want to do an economic analysis of potential new rules, you actually don't know what the baseline is, right? Because you don't know how those services are in fact taxed under treaties currently. So it's difficult to figure out how changes in those rules could affect the revenues that are collected, the risk assessment that people are talking about. And so this question that says, is this information collected, goes not only to data collection and analysis under the Framework Convention, which is what the TOR talks about, but it actually, if this data exists in a way that actually looks at the classifications under treaties right now, it would be really helpful to the Secretariat to know that, because it would help with the economic analysis that you have been asking for. So we thought it was, you know, we'd ask.
Thank you. I have Zambia. Please go ahead, Zambia.
Thank you, Madam Chair, and good afternoon to all the delegates. So I agree with, I think, Saudi Arabia when they mentioned that we need to find out what the problem is with the current existing frameworks for us to be able to determine what the correct treatment for this will be. And I think after Secretariat just spoke, saying, obviously, it's something to explore. So I just thought I would ask, so would this be something like the CRS, but more of, if I could call it, CBS kind of automatic exchange that we're talking about, that it would have to be automatic for whatever services we're receiving from the jurisdictions, let's say, that sign up to the protocol, then we always have to pass on, I don't know, and also what information are we passing? Is it the value of the transactions or the type of services rendered and things like that? I just wanted to just get clarity on that. Thank you.
I think it's you know, it's a scoping exercise we're doing now, and it's part of trying to see if there are cracks in the actual system whereby, you know, this type of income is not reported and we do not get it. So it's trying to focus on the service activities. And you know, my example was what I had heard from a developing countries that wanted to know if these not necessarily digital nomads, but service provider nomads that move from one country to another, they wanted to know if they were providing services from their country. You know, that of course will then depend if they are going to tax that, if we're going to give them taxing rights, but you know, that's part of the analysis that we have to make in the end of the day when we have set, as Saudi Arabia, as you say, Zambia, when we have sort of decided on the fair allocation of taxing rights. But the point, and I think when we heard the question on Monday, and the discussion we had here with the Secretariat and the Chair is that, okay, so we do the fair allocation taxing rights, and the second step then would be, do we actually have the information that we need to be able to tax that in new allocation of taxing rights? It's just a question of checking, basically. But it's just raising the question that we need to hear from you here, and you know, is this important still? And I think it is. You know, and we just need to do as our colleague from Saudi Arabia say. You know, we need to find out what is the allocation, and then to make sure that we have the information that makes it possible for us to tax as well. Singapore, please go ahead.
Thank you, Madam Chair. I just want to also add on to what our colleagues from Saudi Arabia has explained. I do think that it is important for us to have a better understanding of what are the issues that we are trying to solve, and then to do a proper analysis of whether exchange of information is the solution. Just reacting very quickly to some of the questions that you have asked, I think for some of us that have had experience with exchange of information, it is not an easy exercise. It is, in fact, quite a costly mechanism where we need to put in place processes to either collect the information, to think about transmitting the information. And there is always a question of do the recipient jurisdictions, do they really use the information? And for EOI system to be effective, I think it is important for all parties, both the intermediaries that may need to collect the information, pass the information to the tax administration to process, and thereafter for us to then transmit to the receiving jurisdictions. So in the whole scheme of things, there are many parties that will be involved, and there will also be costs on all the parties as well. So I think that it is useful maybe for all of us to have a better understanding of, is this the information that we really need? And if so, whether we are prepared or we are in the capacity to actually put in place the processes to collect the information, and then to think about how do we use the information. My own preliminary view is that probably this will be a matter that needs further discussion before we can decide whether it should be included in the protocol. Thank you.
Thank you very much, Singapore. I have Germany. Please go ahead.
Thank you, Madam Co-Lead. And apologies upfront that I'm a little bit off track, but I missed part of the discussion. So, and I'm now being confronted for the first time with that slide about the exchange of information, and maybe I'm not so, again, I have missed a little bit, but I would just want to share some reflections on that with you. And I was just listening what you said, that we would have to consider which information would be required based on the rules we are going to determine. In an ideal scenario, that would be the case. However, in reality, rules have to be designed based on what is possible in terms of transparency. Because not everything that is desirable is also from a realistic economic point of view is feasible. So, and it is, as was just said by Singapore, it is not as easy as simply exchanging information, unfortunately. There has to be someone who is reporting the information in the first place. So normally there is an intermediary. More typically, this is someone who is subject to other provisions or regulations that already requires them to apply some kind of due diligence. So something like anti-money laundering regulations. For some sectors, service providers, there might be other provisions that prescribe such kind of due diligence, which includes the identification of the person on which the reporting is taking place. But what is typically of a greater interest is to identify the beneficial owner, and that is more difficult. Then secondly, the information have to be reported, and it is always about being, striking the balance, not ending up with an over-reporting and being flooded with information that is never going to be used, that is also very, very sensitive when it, from the perspective of data minimization, data protection, but also the technical infrastructure that is required to do so. And ultimately, it is costly. And it is not only costly for the tax administration to process all the information, but it is more expensive for the businesses, for the service providers, and ultimately kind of the consumers, which have to bear the costs. And this is something one really has to be mindful before simply designing rules that require the exchange of information in order for the verification purposes or to avoid the abuse or misuse or the avoidance or evasion. But it is often enough, it is more wisely to do it the other way around. Thank you.
Thank you, Germany. You had also asked for the floor just before lunch, and I don't know if you want to come back on that. You're very welcome to do it, although it's changing the subject, I suppose. But if you want to think about it, I have the United Arab Emirates before, and then you are very welcome to come back on that if you want to, Germany. United Arab Emirates, please, go ahead.
Thank you, Madam Co-Chair. And I'd just like to pick up on the last point that I think Germany just raised, and that was around the enforcement. And I think we are very much of the view as well that we're finding it quite strange that we're trying to define something that you can enforce when we don't actually know what we're enforcing. So for us, I think it would be much more sensible if we focused on the primary technical issues around the taxation of services before we kind of looked at this topic. And in particular, I think I'd just like to cast our minds back a year ago, and one of the fundamental principles of the Framework Convention as well was the recognition that we wouldn't have a duplication of rules, particularly with existing rules. So I think, as many delegates have mentioned, these kind of systems around exchange of information, they're not easy. For them to be truly effective, you do need to have then assessment procedures in place, and of course all the, like I think it was Michael that just said, the costs around, the IT infrastructure, then the actual end-to-end processes. So I think we're a little bit confused or concerned that we're shifting away from what was agreed that would be the original protocol, was the taxation of services. And at the time we did also obviously discuss exchange of information as well, and it wasn't chosen as a specific protocol. So I think to add it here as an add-on feels like it's a stretch. And I think we should be focusing on the problem that we all agreed that we would focus on, rather than trying to solve things that are just far too complicated to solve in one go in this case. Thank you.
Thank you very much. I have Switzerland.
Thank you, Madam Co-Lead. Thank you, Madam Co-Lead. I will echo everything that was just said by my distinguished colleague from the UAE.
That was quick and short. Thank you. Okay, I don't have any other flags up. I think we understand. Oh, Nigeria. Please go ahead.
I don't think we need to look too far, because exchange of information is critical to the work of tax administration. And if you go to look at the discussions that were had previously, it's a part of the commitment that is expected to feature in the convention. And it's also listed as a possibility of looking at exchange of information as a protocol, having a protocol on exchange of information. Yeah, quite agree with colleagues that currently there are instruments for purposes of exchanging information. But if we cast our mind back to the discussion, I think, in the morning session or yesterday, I think somebody, a delegate, really drew our attention to the fact that there are bilateral treaties that were done or were negotiated during the pre-colonial era. Most of these treaties don't have provision for exchange of information. So that is a challenge that we must consider. The second issue, I think Singapore and some other have also reiterated it, that the exchange of information, yes, in theory, it looks so simple, but in real application of it, it is not as simple as it seems. If you consider developing countries, and especially on the African continent, I can tell you that the number of countries that are able to implement exchange of information are just very few, maybe about 5 or 6 or so. because of the strict requirements of confidentiality and data safeguards that must be met. So it's not as if it's working effectively for everybody. So if we are able to have a more simplified rules or platforms, and we have an idea of what exactly the data that we want to source and they are available, so it may not be a bad idea, but I agree with suggestion by others that for now we are dealing with the service article. Is this the appropriate place where we should have it, or should it be in the framework convention? I think since this commitment has spoken, has stated that it could be a part of, it's a commitment under the convention, then it could feature under that convention. Thank you, Chair.
Thank you very much. Yes, I think what we were thinking of is just to identify gaps, because I think we all recognize the tremendous work in other forums on exchange of information and the whole, framework that already exists in this particular area. And I think the only thing that we were concerned about, it was someone who raised the issue on Monday, and I also think that we still need to keep in mind when we design our rules that it should be possible to get the information in order to be actually able to tax it as well. And even if we don't include anything in our protocol on exchange of information, if there's anything else, but we should be aware of it. And so any problems that we have and anything that we identify with allocating our taxing rights that affects that protocol in its implementation, at least we should be aware of it. I have Sierra Leone. Please go ahead.
Thank you very much. Thank you very much. So I just want to, share Patricia's concern about tax administration that may possibly not have, real-time information from taxpayers involved in cross-border service. So imagine if advanced economies have such challenges, how much more, developing economies. And us in Sierra Leone, we're having such issue as with there are increasingly people involved in cross-border services, and we're relying on them to actually declare the taxes, their income, and pay the correct taxes. And if they don't, we don't have the necessary mechanism to get such information. So as colleagues from Zambia and Saudi Arabia has expressed, there are existing framework that governs exchange of information. And these frameworks or rules need to be critically considered as we're discussing how we develop rules and framework that involves sharing of information when it comes to cross-border services, which is really critical for us in the developing economies. Thank you very much.
Thank you very much, Sierra Leone. I don't have any other hands up. I will give the floor to the Secretariat. Patricia, please go ahead.
Thank you, Lisa-Lot. I just wanted to come back on a technical point that the delegate from Germany had raised and the United Arab Emirates, and that is about determining beneficial ownership, layers of intermediaries, the cost of implementation. All of that is obviously a key point when you are dealing with CRS because of the layers of intermediaries between the paying company and the recipient. But it is not the case with respect to most services, right? Michael seems confused that I said that, so I'm sorry, I was just going to leave it at that. But remember, I spent 4 years on the CIV and Trace project learning about the plumbing of the international financial system. So in the case of securities and a lot of the financial accounts that we're talking about in CRS, you have a company that is paying a dividend. It has a paying agent. That paying agent pays to one of the, in the simplest case, a clearing organization. The clearing organization pays to a global custodian. The global custodian pays to the local financial institution where the customer may have the account. In the simplest case, what was that, 5, 6? We're talking about services. The services are not, in most cases, not going to go through a paying agent because they're paying to a few people, not thousands of shareholders or thousands of bondholders. And so it's probably the paying company paying to a single recipient, possibly to the recipient's bank account, in which case there would be a record. So I fully acknowledge the complications of CRS. I fully recognize all the costs that have been referred to. I understand the cost to developing countries that have prevented them from participating in CRS, among other barriers. But let's not assume that the same costs would be incurred here, because the situation is very different.
Thank you for clarifying that point, Patricia. And I think, again, just repeating, we keep it on the table in order to just understand and keep it possible for any, allocational taxing rights that we would have to be effectively able to be taxed where it corresponds. So we'll keep that on the table for future, not necessarily into our protocol, but we should be aware of it. I think that's the conclusion I get to today. So we have actually, I think we have we want to have a coffee break. So let's have let's see if we can do 15 minutes this time. So we have a coffee break for 15 minutes, and we can put up, before we go, let me do this. We have a third slide, which also has been raised questions from from Monday, I think. Could you put up the third slide, Katie, so we can have a look at this and see if you can think about this over coffee. I don't know if you want to go through it, or do you want a presentation, and then we take the coffee break? Yeah. Okay. Do you want me to do it? Yeah.
So I hesitate, again, this was not a question raised by the Secretariat. This is, the first question was, it was suggested that Protocol 2 would have to have its own dispute resolution mechanism in it. And I don't remember who raised it, although it did also has come up in at least one work stream meeting as well. And so the question, so that sort of general question led to the sort of follow-on questions. If you did want to have such a before you draft something and put it in the protocol, you first have to decide what mechanism do you want to use to resolve those. Do you want to use Protocol 2? Would you want to apply a state-to-state dispute resolution mechanism that would apply to disputes under the Framework Convention? This is the type of dispute resolution mechanism that is referred to in paragraph 13 of the TOR. Would you want to put in a map-like procedure so it is also state-to-state resolution, but it's specific to Protocol 1, so it'd be more like a map? Or just leave it to normal domestic litigation approaches, where the investor, if the investor feels that one of the parties to the protocol is not applying it, they could go to correctly, they could go to court. And that will depend a bit on how specific the protocol is. So these are the options that we came up with this morning. There may be others, but before you think about, you sort of need to think about who can bring a case and how do you want it resolved. And remember, keeping in mind that all the protocols are optional. We talked about it. So you can't just say everything is going to be resolved under Protocol 2. I mean, you can say that in Protocol 1, but it is possible that there are parties to Protocol 1 that are not, where a dispute arises, and they are not both parties to Protocol 2, which is why this issue arises.
Thank you for that, and then you have some time to think about this. We'll have 15 minutes coffee break.
No, it's 10 of. No, it's 4:50.
We have 15 minutes, and we will resume 10 to 5.
So, dear colleagues, I think now we are opening the floor to get your comments and reflections on the questions which is in the screen right now, and to know your thoughts about it. So the floor is opened. Distinguished delegate of Poland.
Thank you, Mr. Chair. Maybe I would not refer to all of the questions, but I would like to comment on something here. Having in mind that, let's say, in one of the scenarios, we are going to have this self-executing protocol on the services. As I said before in my previous intervention, it is kind of small double taxation treaty on the services, yes? So I cannot imagine a situation when this kind of treaty could be effective without the effective mechanism for the dispute resolutions based on the cases, concerning the cases based on the application of this kind of protocol provisions. And we have also Protocol 2, which is going to be like comprehensive solution for the dispute resolution for the international cross-border tax cases, let's say. We do not know yet the precise scope, but generally I understand that this is the reason why we have chosen this topic for the second protocol. It is that we want to cover all the possibilities to solve the international taxation cases between the parties of our convention and the protocols. I think that this protocol should concern also the protocol first, yes, because duplication and having the same provisions in Protocol 1 and Protocol 2 would not be the good solution because it would be the creation of the two simultaneous systems, which it is, in my opinion, not very good way to do it. But there is a but, because if you have a protocol, first protocol, without any dispute resolution mechanism, so in my opinion, the only, and we have on mind that the effective way to apply the provisions of this protocol is also having some dispute resolution mechanisms. So in fact, we should think that, that the consequence of this kind of thinking should be that the Protocol 2 for the countries which sign Protocol 1 should be mandatory, because without having any dispute resolution mechanism, the Protocol 1 wouldn't be effectively applied. So I think that our decisions during the February session, the consequence of this decision is that if we want to have the Protocol 1 as a self-executive instrument, then it is normal consequence that we should then be a party also to Protocol 2. Until we would not decide that we will go for the kind of solution based on the BEPS MLI. Because then, in fact, the situation would be totally different, because then we would have in Protocol 1 only provisions modifying double tax treaties between the parties of this protocol, and double tax treaties already contain the dispute resolution mechanisms. And in such a situation, Protocol 2 could be totally independent, separate way and alternative to solve disputes in the international taxation without this close connection and with the Protocol 1. So I see this situation this two different way we can go here. But in the first case, when we see that the protocol one should be like self-executive international agreement, then the consequence of this is that protocol 2 should be just simple mandatory instrument. Thank you very much.
Thank you very much for that input, Poland. I have Saudi Arabia. Please go ahead.
Thank you for giving me the floor. I think this takes us to our intervention in the first session, is that we are talking about we will have a protocol for dispute resolutions, and then we also discuss dispute resolutions under the convention itself, and then we have the dispute resolution here for the services, digital services, or cross-border services taxations. We are talking about optionality under for these protocols. So it is optional to join one, but not the other. So we cannot envisage a case where a country join the protocol on cross-border, but not the dispute resolutions one. Therefore, we put a suggestion at the beginning is that maybe the protocol on dispute resolution focus only on issues that we have today and dispute that are arising today, because not everyone have a tax treaty with the other. And each protocol, like the cross-border services and maybe future protocols that will come, each should have its own dispute resolutions mechanism. Maybe to the issues of leaving it through domestic litigations approaches, again, I don't think that this might be the best outcome, because we are talking about multilateral instruments and allocation of taxing right. So definitely if a jurisdiction increase its own allocations of taxing right, that will impact the other jurisdictions, and that will be a nightmare for the taxpayers, which we should definitely keep we focus on here, that certainty and dispute resolution, dispute prevention is something very important for all of us and for all of our taxpayers. So something like MAP procedures would be definitely more preferred, and definitely we are open to more options and alternatives for that matter. Thank you.
Thank you very much for that, Saudi Arabia. I have the United Arab Emirates. Please go ahead.
Thank you, Madam Co-Chair. As has been raised in the past few days, I think what is important is to determine whether the scope of this protocol will be covered by existing international model tax treaties. So, for example, if it is, then the dispute resolution mechanisms in those tax treaties may apply. And if we devise a separate mechanism which also applies, then you might end up running counterintuitive to Protocol 2 in terms of increasing tax disputes regarding the correct dispute resolution mechanism. So therefore, we strongly advocate, as we have done, that the committee should not seek to reinvent the wheel and draw on the productive work regarding dispute resolution mechanisms, including that within the UN Model Tax Convention. Thank you.
Thank you. I think we do need to clarify that the scope that we're looking at now is not only actual relationships on bilateral tax agreements. Yeah. So it is wider. I would like to make absolutely clear. It might have been somehow misunderstood, because we were talking about one of the problems that developing countries had was with their actual tax treaties, but the scope of our work is actually wider than that. So we must keep that in mind. Thank you, United Arab Emirates. I have Brazil and then the Russian Federation. Please go ahead, Brazil.
Thank you, Chair. I would like to be as straight as possible, as direct as possible. At the current stage, it's quite difficult to choose for any option and to have a sound perspective on which approach should be taken, because we don't know whether we will restrict it to tax treaties. We will just an instrument to put on top or to modify tax treaties, or whether we will make it a bit bigger than the scope of tax treaties, as you just mentioned. So I think that it's, for the moment, it's quite difficult to take a position on that. I hope that from our discussions, I think that to the full extent possible, we put a lot of weight on administrability and simplicity of whatever we can find here as a scope for protocol number 1, and then also that would reflect on what the mechanisms should be allowed to solve disputes. So if we find the simplest possible solution for the scope of protocol 1, then we would calibrate accordingly how we have to solve it, whether through the connection with the protocol number 2, or maybe as part of what was just mentioned, as part of the MAP resolution disputes under double tax treaties as usual. So I think at the current stage it's quite difficult to take a position, and we will have to see more on the scoping exercise to define what would be the optimal dispute resolution mechanism. Thank you.
Thank you, Brazil. I have the Russian Federation and then France.
Спасибо за предоставленное слово. Постараюсь ответить по порядку поставленных вопросов, по крайней мере, попытаться ответить на данные вопросы. Безусловно, споры должны быть разрешены, но вот каким вот образом, посредством каких механизмов? Относительно первого вопроса, могут ли быть они разрешены только посредством второго протокола исключительно? Наверное, нет, если мы говорим о том, что второй протокол может быть опциональным. Тут согласимся с секретариатом, поскольку страна может быть участницей первого протокола, второму протоколу не присоединиться. Но вместе с тем, если второй протокол будет разработан и будет предлагать эффективные механизмы для разрешения споров, то, наверное, страны-участники протокола по услугам заинтересованы быть стороной протокола по разрешению споров. Не знаю, насколько мы можем поставить сейчас вопрос относительно обязательности протокола второго для разрешения вопросов спорных. Не уверена, что это предмет нашей дискуссии сейчас. Но второй протокол в случае, если страна будет участницей этого второго протокола, может применяться для разрешения споров по первому протоколу. Посредством механизма, который будет заложен в самой конвенции, наверное, этот вопрос ответить сейчас сложно, поскольку мы не знаем, какой механизм будет заложен в самой конвенции для цели разрешения споров и как он может быть использован, будет ли он универсален или будет ли он достаточным. Поэтому на него сейчас преждевременно ответить, будет ли это механизм тот, который позволит разрешать споры не только по первому протоколу по услугам и, может быть, по следующим протоколам. У нас впереди многие другие вопросы, которые стоят на повестке, другие протоколы, которые будут разработаны. Подойдет этот механизм или нет, будет он универсальным или нет, на этот вопрос пока, наверное, сложно ответить. Третья позиция относительно использования процедуры, взаимосогласительной процедуры МАПов или какой-то похожей процедуры в рамках первого протокола дополнительно разработать, может быть, стоит на это обратить внимание. Поскольку если у нас будет по первому протоколу международные конвенции, которые будет определенным образом взаимодействовать с существующими соглашениями налоговыми, то взаимосогласительные процедуры, предусмотренные в соответствующих двусторонних конвенциях, они, наверное, автоматически будут применяться к спорам двусторонним, вытекающим из первого протокола, и их можно будет использовать. Насколько они эффективны и во всех ли соглашениях они есть, это вот уже другой вопрос. Возможно, что не всегда их можно будет использовать. В в этой части есть еще одно опасение. Из первого протокола могут возникать не только двухсторонние споры, но и многосторонние, трехсторонние, учитывая, если он будет покрывать и чисто цифровые услуги, деятельность МГК. В таком случае существующие мапы по двусторонним соглашениям, скорее всего, это не разрешат. Нужен будет отдельный механизм, эффективный для разрешения этих споров. Поэтому либо это отдельный механизм в рамках первого протокола, который будет позволять разрешать споры, либо же при наличии хорошего инструментария по второму протоколу можно к нему ссылаться. И страны в этом, наверное, сами будут заинтересованы. То есть это вопрос, наверное, дискуссионный и вопрос будущих тоже заседаний. И последний вопрос относительно национальных подходов и мер. Никто не запрещает их использовать, но я соглашусь с предыдущими выступающими, наверное, не всегда они могут быть эффективными при разрешении трансграничных споров, и не всегда они могут прийти к соответствующему, возможно, решению, удовлетворяющему все стороны. Поэтому, на наш взгляд, либо это второй протокол, если он будет разработан и достаточно эффективным, тут вопрос с опциональностью, и либо же это своя МАП-процедура, похожая процедура в рамках первого протокола, которая позволит разрешать споры, возникающие из него, не только двусторонние, но, может быть, и многосторонние. Спасибо за внимание.
Spasiba. Those were very good considerations that we need to consider. So thank you for that, Russian Federation. I have France and then Italy.
Merci, Madame la Présidente. Je me permets de poser un peu une question sur le champ éventuel de nos travaux, ou en tout cas du protocole tel que vous venez de le dire ou de le rappeler, ou j'ai peut-être manqué une étape. Mais moi, j'avais compris que soit on est dans une hypothèse dont on a parlé hier matin, qui est en dehors du champ des conventions, où à ce moment-là, on en a discuté hier, mais chacun est un petit peu maître chez soi. Soit on est dans le champ effectivement de conventions, où là je comprends bien qu'il y a un blocage juridique, que éventuellement les protocoles qu'on est en train de discuter pourraient débloquer, on va dire. Et donc voilà, mais alors à ce moment-là on est bien dans le champ conventionnel. Et si on est dans le champ conventionnel, pour revenir à la diapositive de tout à l'heure, il y a bien un mécanisme d'échange d'informations et il y a bien un mécanisme de résolution des différends. Ou si on est encore une fois en dehors du champ des conventions, à ce moment-là, chacun est de nouveau maître chez soi, d'une certaine manière, et il est en capacité de mettre en place des retenues à la source ou d'autres mécanismes pour taxer les rémunérations pour prestation de services. Mais alors à ce moment-là, je ne vois pas dans quelle mesure il pourrait y avoir de différents, puisqu'encore une fois, si je n'ai pas de normes juridiques qui me limite, dans quelle mesure est-ce que il pourrait y avoir un différend avec un autre pays. Donc j'ai un peu du mal à comprendre la vision dont vous avez parlé tout à l'heure, du fait que le champ du protocole pourrait être au-delà de la résolution de difficultés qui sont issues des conventions fiscales. Merci.
Merci. I have Italy and then Switzerland.
Thank you, colleague. Thank you, Chair. And it's difficult to answer now, to reply now to these questions, because, of course, it's quite premature without looking at what the Framework Convention says. For instance, we had thought that the Framework Convention was those overarching legal instrument where the commitments are translated into legal terms. So we expect that all the commitments are translated there. So also the dispute prevention and resolution, as well as the exchange of information, the cooperation, and others. So perhaps we imagine that the Framework Convention would have some legal obligation to the parties to include in their domestic law effective provision to prevent disputes, because this is more a question of domestic law than on treaties, and then perhaps making a reference to the second protocol for the implementation rules of the dispute resolution. Then there is the problem of the optionality of the protocols, of course. But all the parties should be more encouraged in signing as much as possible all the legal instruments we are trying to do. What we want to say is that perhaps we should end up in some agreement in this framework convention, looking at the drafting and seeing if it really covers the dispute that may arise on the framework convention itself, because we will have definition on the framework convention, for instance, which is a field where dispute may also arise. And then see how we can end up in the second protocol, possibly allowing options so that the majority of countries may be party of that. What we would not like to lose, if some provisions are included on Protocol 1 as far as dispute are concerned, to lose completely the approach on prevention, because for intercompany services, the prevention of dispute is also a very important issue. And another thing that we would like to have, having this possibility of designing the new architecture, is not to lose the multilateral option that this new instrument gives. So let's go step by step and try to translate into legal terms the TOR in the Framework Convention, and then discuss again when we have more awareness if we could really end up in some agreement on Protocol 2. Maybe it's useless to duplicate something in Protocol 1, but at the moment we are not able to say that. Thank you.
Yeah, thank you, Itil. I think, I think you're right. You know, we can't really say it's duplicate unless we have both of them ready. So thank you for the considerations and the input. I have Switzerland and then India.
Thank you, Madam Co-Lead. I agree with my distinguished colleague from Brazil that it is early to actually answer many of these questions, especially until we know the content of Protocol 1. We have just seen in our previous discussion that there are different options of a amending protocol, or maybe you still need to do bilateral agreements next to the protocol, and that will make a big difference in the answers to the questions. Here we can maybe think, what can we cross out to simplify the situation? And I think the last option, which is normal domestic litigation, at this point we can already say that wouldn't work to handle problems of the application of a tax treaty, which is Protocol 1. Protocol 1 will be a binding international treaty, and you need a provision in a binding international treaty to handle those disputes. And finally, when we do get into the details, once we know more about Protocol 1, I think I'll echo what the UAE said on avoiding to reinvent the wheel and duplication in cases where, for instance, Protocol 1 is adding let's take the option where it's adding one new article to an existing tax treaty. So that's all I have to say.
Thank you very much, Switzerland. Just I had a quick chat with the chair, and of course, when I mentioned that we shouldn't have duplication, there is the point made by the Russian Federation that if we have two protocols and you don't need to sign both of them, you might need to have, rules in both of them. So, but that is still to have to be considered, of course. So I have India and then Colombia. Please go ahead, India.
Thank you, Chair. We agree that there is a merit in having a separate dispute resolution mechanism for each of the protocol, particularly given the possibility that some member states may not agree to certain provisions of Protocol 2. However, this naturally raises the question of whether the dispute resolution elements developed under Protocol 2 could be incorporated into other protocols, or whether we would need to design an entirely new mechanism each time for every protocol. And though I believe that it is premature at this stage because we really don't have a complete picture of either of the protocols, nevertheless, in the interest of efficiency and to avoid unnecessarily, which has been also stated by many of my colleagues, reinventing the wheel, it would be prudent to develop a framework that provides a common set of dispute resolution options adaptable to different protocols. And such a framework would offer a range of procedural choices and safeguards, enabling countries to select the approach that best aligns with their legal systems and policy preferences before acceding to the obligations under the protocol. And I submitted in the morning also, this flexibility would help accommodate diverse domestic positions and in turn encourage broader participation. Thank you.
Thank you, India. Colombia, por favor, adelante. And then Senegal.
Gracias, estimada co-líder. Desde Colombia apoyamos lo manifestado por Brasil. Realmente consideramos que estamos en una etapa prematura en la que es difícil resolver estas preguntas sin aún tener claro el alcance del protocolo 1 y qué nivel de detalle va a tener este acuerdo. Entonces, una vez lo tengamos definido, podremos decidir cuál será el mejor mecanismo para resolver las disputas respecto a este protocolo. Por otro lado, estamos de acuerdo en que es difícil dejarlo cerrado al protocolo 2, porque como ya han mencionado varios delegados, es posible que, dada la opcionalidad, hayan países que firmen el protocolo 1, pero no estén de acuerdo por confirmar el protocolo 2, y por lo tanto, pues tener esas dos posibilidades hace que seguramente sí se vaya a requerir introducir algo dentro del protocolo 1 respecto a este mecanismo de resolución de controversias. Sin embargo, también tendremos que ver, según lo que se concluya en este protocolo, si la otra forma puede ser bajo la Convención Marco sobre los tratados de doble imposición que ya se tengan, o si definitivamente sí se requiere tener un instrumento dentro del mismo protocolo. Pero aún es difícil decidirlo. Muchas gracias.
Muchas gracias, Colombia, por señalar las opciones que vamos a tener. Gracias. Senegal, s'il vous plaît.
Merci, Madame la facilitatrice. Donc, je pense, comme l'ont souligné certains délégués, à cette étape, nous ne pourrons formuler que des observations d'ordre général. Et la première observation est que nous ne connaissons pas encore la portée du protocole 1. Quels sont les différends que la Convention pourrait générer? Et ce seront des défis de caractérisation, ce seront des défis d'interprétation. Nous n'en savons pour le moment absolument rien. Donc, il est très prématuré de pouvoir maintenant avancer sur le mécanisme par lequel les différends qui seraient générés par cet instrument devraient être résolus. C'est dans cette perspective, d'ailleurs, que nous voyons à cet instant une certaine incohérence. Comment se ferait-il qu'un différend qui naîtrait d'une convention qui a une portée obligatoire, qui a des effets obligatoires et contraignants, puisse être résolu par un protocole qui a des effets facultatifs? Ça signifierait que, donc, même si effectivement, donc, cela ne garantirait même pas la certitude juridique. Parce que si moi, mon pays, Sénégal, n'est pas signataire de ce protocole 2, et effectivement nous avons un différend qui est né du protocole 1, comment nous pourrions être partis à cette résolution des différends? Donc ça pose réellement un problème, et je pense qu'il faudrait que nous puissions aller davantage dans la substance des différents protocoles pour pouvoir s'y prononcer davantage. L'autre élément, c'est aussi par rapport aux dispositions nationales. Les dispositions nationales aussi entre États sont assez relativement limitées. C'est entre partenaires conventionnels. Et on peut avoir des différends, comme l'a souligné la Russie, qui naîtraient d'opérations qui présentent un caractère multinational. Le cas, par exemple, du numérique. En ce moment-là, est-ce qu'on pourrait se suffire uniquement à certaines dispositions qui sont nées de traités? Je ne pense pas. Donc, je pense qu'à l'état actuel, beaucoup de développements doivent être faits. Beaucoup d'études approfondies, notamment dans la substance, doivent être menées pour que nous puissions nous y prononcer de façon plus détaillée. Ce qui est souhaitable, par contre, serait que chaque protocole puisse avoir, chaque instrument juridique puisse avoir des dispositions sur la résolution des différends. C'est ce qui est souhaitable et ce qui est garanti mieux à la certitude fiscale. Je vous remercie.
Merci beaucoup. Senegal, I have Ghana. Please go ahead, Ghana.
Thank you, Madam Chair. And I wish we had such questions when we're fresh in the morning, not when we are so fuzzy after lunch. But I'll try. Now, we had some discussions about this in work group 1, actually. And the general discussion was around having two considering the dispute resolution mechanism in paragraph 13 of the TUR under the framework, separate from the dispute resolution protocol, such that the one in the framework would look more at the state-to-state issues when it comes to the framework, and then the one in protocol 2 would look at the disputes that will arise between states and, if I should use the word, taxpayers, when it comes to either cross-border or whatever other disputes that may arise. Now, just listening to to LSDs right now, the question really that it raises is, what if somebody doesn't sign on to Protocol 2? I think there's something interesting in the military when they ask for volunteers. What I do know is that they will ask for volunteers, that want volunteers, and then they select you've been volunteered. I think that Protocol 2 might end up having to be something which, if we want to sign on to the Framework Convention, we might all have to sign on to anyway. Otherwise, I don't see how we are going to resolve our disputes. It means that we are leaving ourselves wide open when it comes to resolving disputes under other protocols, because we wouldn't have any basis to do that. So as we go along, I think it's something that we'll need to think through very carefully. I mean, as we said, the protocols are optional, you can sign on to it. But the question is, how optional will such a protocol or Protocol 2 be in terms of how we want to go forward? So these are questions, and that's why I said that sometimes these questions shouldn't come when we are fuzzy-minded. It should be when we are fresh. Thank you.
Thank you very much, Ghana. I don't have any other member participants asking for the floor, so I give the floor to stakeholder 10, the Bombay Accountancy. Please, go ahead.
Thank you, Chair. Even late in the evening, it's possible to contemplate a structure of documents wherein the provisions are linked to each other. So what I intend to say is that we are at a designing stage. It's for us to design the documents, the contents of it, and how they get linked. So it's possible that we can think of Protocol 2, which may contain 2, 3, 4, 5 methods of dispute resolutions. Now, parties who are not signing Protocol 2 may still adopt one of the methods contained in the Protocol 2. So Protocol 1, dealing with services, may say that if there's a dispute on services-related issues, then paragraph 13 to 25 of Protocol 2 will be applicable. And this paragraph need to be designed in such a manner that each of them represent a separate capsule. So there could be chapters or separate capsules or sections within Protocol 2, which will contain different methods. So a person adopting that method need not necessarily adopt all the methods. So tomorrow, after 5 years, 10 years, we may have 15 protocols. Are we going to keep on repeating the dispute resolution methods in all the protocols? Or we can have a one single protocol, which is protocol 2, which can act as a warehouse of methods. And whichever the parties want, they can keep on linking the method, they can keep on adopting the method from protocol 2 without signing the entire protocol, without accepting everything which is there in the protocol. Thank you.
Thank you very much for that input. I now have NGO2, which is the major group for children and youth. Please go ahead.
Thank you, Chair. I'm speaking on behalf of the Aft1 Children and Youth constituency of the Major Group for Children and Youth. Chair, I would like to remind everyone in this room that this global tax convention will not solely affect the economies of countries across the globe, but also chart the course for the future. Therefore, it is vital that we design a convention that doesn't merely serve as an economic...
Could you speak a little bit slower, because we have interpreters trying to follow your speed.
Okay. Apologize for that, but a future-proof solution that brings us closer to the completion of the 2030 SDGs and promotes countries to participate on an equal playing field. Firstly, precise definition that clarification are essential in the creation of equitable future-proof tax convention. The current ambiguity surrounding forms of taxation not only results in inconsistent interpretation by tax authorities and courts, but also drives us further from a globally recognized and acceptable convention, which allows all countries to contribute while respecting their interests and sovereignty. An equitable, sustainable, and future-proof solution is unachievable when ambiguous language obstructs a clear vision for the future. Chair, we believe that children and youth must be involved in these conversations, offering our expertise and perspective to shape policies and definitions that are able to mold with the future and address realities rather than ideals. Secondly, we recognize and respect the sovereignty and interests of all countries. Therefore, children and youth call for a convention which establishes a strong legal base that works in tandem with countries' domestic policies. In cases where the implementation of aspects of the protocol is hindered by domestic policy, we believe that the convention should encourage and uphold pre-existing bilateral treaties. Distinguished delegates, Mr. Chair, colleagues, let us work alongside children and youth in the creation of a convention that prepares for the future rather than trapping us in the past. Thank you.
Thank you very much. I have Ataf, please. Go ahead.
Thank you, Madam Chair. The question is a difficult and critical one, but our preliminary thoughts will still derive from the TOR. Paragraph 13 of the TOR spoke about dispute settlement mechanism in the context of the framework. So preliminarily, we think one of the ways we can go about resolving this issue is to look at developing that mechanism in such a manner that it can attend to disputes also arising from the administration or implementation of the protocols. And I say that because while we elaborate the relationship to exist between the protocols and the framework, one key issue which we must underline is that the protocols will be implemented by the governance architecture that is established by the framework. That being the case, we may want to elaborate that mechanism and empower it in a manner to help resolve disputes arising from the protocols. The details of how the mechanism could be triggered could be a subject matter of the protocols themselves. That is to say, in instances bearing this and other possible terms, the mechanism could be triggered. That aside, we are also looking at ensuring that the protocol 2, which is on dispute resolution, do not just simply become a kind of, because if we have dispute articles in all the protocols, and then we have protocol 2, what will be the purpose of protocol 2? Since all the independent protocols will already have dispute resolution articles or mechanisms. So we have to look at that critically and see how we are able to make progress. The alternative would be to say that dispute resolution protocol should be mandatory for any member signing on to the framework. But I think that ship has sailed, and we just have to find a way to work around it. We thank you, Chair.
Thank you, Ataf. I have, let's see, there's only one more in person that, Nigeria. Please go ahead, Nigeria.
Okay, thanks, co-lead. I think it looks simple on the screen, but really, it's not really as simple as it looks. And probably this should have been shared early in the morning to enable delegates to really discuss this and be able to give a good opinion to the Secretariat. It is certain that we can prevent dispute, but we cannot avoid it. But we must be clear what kind of dispute do we envisage under this first protocol. It could be a dispute between the revenue administration and the taxpayer. And if it is such, because we know that the protocol itself will not give you taxing rights, you still need to revert back to your domestic provisions to tax the transaction. So if it is because I've raised an assessment and the taxpayer has disputed, then such taxpayers would therefore be able to use the domestic provisions of the respective jurisdictions to address or to resolve that dispute. We know that dispute could also arise from misapplication or misinterpretation of the provision of the protocol, that is between two states. So if we have that, and because of the reason for the optionality, that you said that somebody or a jurisdiction might sign on to the first protocol without signing to the second protocol, we may then have no choice than to have a kind of article or provisions within that first protocol to be able to resolve issues like state-to-state disputes that could arise from such. I think I just ended there. Thank you.
Thank you, Nigeria. And I don't have any more hands raised, so I give the floor back to the chair. International Chamber of Commerce. Please go ahead.
Thank you, Madam Chair. I think I will be very, very brief, and I will also be slow. This is just a short comment to emphasize once again that for businesses, tax certainty is of paramount importance. So it is indeed important to stress out that for Protocol 1, whichever solution will be drafted and discussed in the next session, but at the end, like the solution that will be contained in Protocol 1 needs to have a way of solve the dispute that might arise. So we're not able to tell you which form of mechanism should be adopted, but we just want to emphasize that it's important to have a mechanism in place to solve any dispute that might arise from Protocol 1. Just as a quick remark on the past few days, in the course of the previous days, there's been a lot of questions that have been raised and discussions. These are strongly linked, we believe, to the different business models, as someone also have raised. Even the discussion we had today. And given all the questions that have been raised, we believe it's really important to think about this Business Advisory Council or a way to dialogue with taxpayer. I'm not able to give you the explanation of one single business model because there's not size that fits all. Business models are very different. So yeah, we just encourage you when you will be thinking about the solution to be drafted to really engage with the taxpayer. We are able to explain and engage with you to explain business models and any information you may need to make informed decision. Thank you.
Thank you very much from that ICC. So I will then give the floor to the chair back.
Thank you, Lisa. I have here the screen request from 866. So if you can identify yourself, please.
Mariana Beraldo from Novatex Research Lab. I think Ataf made a very good point, important point, because if we are going to have the dispute resolutions rule in the convention, in Protocol 1 and Protocol 2, do we really need an optional separate protocol? This protocol will have some will be efficient. We don't know, because we are going to discuss different rules in different documents. I know that it's really it's really early to discuss this, because we don't have the content like Brazil said and other jurisdictions, but it's to think about what's going to be the proposal of Protocol 2. I think it's a really important task to think about before we continue these discussions. Thank you.
Thank you. So I don't see any more hands from member states or multi-stakeholders, and I think because of the discussion today was very, not only today, for these 3 days for Workstream 2 actually was very fruitful, and we learned, and I personally I need to admit that I learned a lot from this discussion. You bring our attention to a lot of points that was very necessary for us in drafting. Some of them were already like question marks in our heads, and some of them you bring it here, and we saw it, and it was very good for us as we're moving further in this process. So I think today, now we reach the end of this session, and by this we're getting to the end of the discussions for Workstream 2, Protocol 1, taxation of cross-border services, and the next step will be in update in Nairobi, that will be followed also with some discussions in February on the solutions. So I would like to thank you all and for all of this intervention and very good learning and fruitful discussion. I think everyone deserves a bonus of going back home like 15 minutes earlier than it was planned. So I would like to thank you all, and tomorrow we're going to start deliberations and discussions for Workstream 3, Protocol 2, dispute prevention and resolution, with our 2 co-leads, Maria, Marlene, and Michael. So looking forward to see you all tomorrow in the same room at 10 a.m. Have a good evening. Thank you.